Good morning, everyone. I'm Tiffany Coet, Assistant Executive Director of Connecticut Association of Schools. Thank you for taking time out of your busy day to attend this legal updates webinar. Everyone's favorite for the year, an annual favorite. Today's webinar is presented by our distinguished guest, Tom Mooney and Dori Antonetti from the School Law Practice Group. Before I begin, I want to thank our corporate sponsors, Horace Mann and MCM Fundraising, whose ongoing support helps us to bring high-quality professional development to school leaders in Connecticut. Horace Mann knows educators are taking care of our children's future, and they believe that children deserve someone to look after, or that educators deserve someone to look after theirs. Horace Mann provides auto, home, and life insurance to protect what educators have. And at MCM Fundraising, they believe that by exceeding your expectations, they will build the solid partnership you deserve with great customer service that takes the guesswork out of running a successful campaign, which makes the fundraising process easy and profitable. I also want to go over logistics of how we will proceed with the webinar today. All of you in the audience are muted. You can share any questions you have using the Q&A feature during the live presentation. We're recording the webinar and we will make that recording available to you in the next few days. Now, let me introduce Tom Mooney, a man who needs no introduction but is about to get one. Tom is Chair Emeritus of Shipman Goodwin School Law Practice Group. Tom represents clients in all areas of school law, including labor negotiations for certified and non-certified staff, teacher tenure proceedings, grievance arbitrations, freedom of information hearings, student disciplinary matters, special ed disputes, and all other legal proceedings involving boards of education. Drawing on his decades of legal practice, Tom's philosophy is straightforward. The best legal problems are those that are avoided. And I also would like to say that for those of you who do not have the practical guide to school law, and for those who do have a 9th edition or earlier, the 10th edition is in publication now and can be pre-ordered through CABE. So if you do not have that or you have an older edition, it is an invaluable resource for educators. And Dori Antonetti is a member of Shipman Goodwin's School Law Practice Group, where she represents a wide range of educational institutions, including both public and independent K-12 schools, in a variety of education and employment matters. In her day-to-day work, Dori draws on her unique experience as a former educator for Teach for America. This experience, coupled with her time as a hearing review officer for the New York City Office of Labor Relations and a kindergarten teacher in New York, allows her to analyze issues from a very practical perspective, which brings significant advantages to her clients. So Dori, Tom, and the entire School Law Practice Group are good friends to CAS. We're so thankful they could be here to share their expertise today. So without further ado, Tom and Dori.
Good morning. It's good to be with you this morning. And every year, the General Assembly surprises us with its energy. And this year is no exception. We have any number of statutes to go over. So it will be a bit of a forced march, but for the intellectually curious, on our website, which is indicated at the end of this presentation, ctschoollaw.com, we have the complete statutory legislative update, and all of the public acts that are referenced are linked, so you can actually read the statutory language if you're so inclined. But I'll jump right in with one of the major changes in the statutes, and that is that for the 6th time since 2002, the General Assembly has revised the bullying statute. And this revision is comprehensive and significant. It requires that school districts implement a new school climate policy yet to be written, and a bullying complaint form still yet to be written. It does redefine previous terms and provides new terms for implementing the school climate policy. It updates the roles of the related personnel and establishes a new annual training requirement. Some of the details are that the Connecticut Association of Boards of Education is now charged with the responsibility for developing and approving a school climate policy. But once they do that, then a separate group, the Social Emotional Learning and School Climate Advisory Collaborative, must approve that school climate policy. And we're curious whether that's going to be a simple approval or an iterative process back and forth to get to the school climate policy, which is a cornerstone of the new approach to bullying. And I just want to take a moment to say that I'm skeptical quite often of legislative initiatives, but these changes seem very appropriate. Over the years, it's been a bit of a frustration that the bullying statute has been bimodal. That is, you investigate and you either determine you verify bullying or you don't verify bullying, and people are disappointed on both sides of the issue. This is a process. This new approach is more procedural and incremental, so that you don't jump right to that either or analysis. And so under the new approach, the boards of ed must adopt and implement a new policy by the July 1, 2025. But as we go forward and keep our ear to the ground, we're going to hear when CABE comes up with this policy, when it's approved by the collaborative, and at any point then, school districts are going to be free to adopt the new bullying approach. As we look ahead, we also see that the collaborative is charged with the responsibility for developing school climate standards based on national recognized standards, creating a uniform bullying complaint form that we're all going to be using, and providing guidance on the implementation of the school climate policy developed by CABE and adopted by the collaborative. The new statute provides definitions to the new definitions to terms. And interestingly, this is a bit of a return to the roots of the bullying statute. As some of us remember, bullying was defined originally as actions by a student or a group of students to harass or intimidate another student. And that harass and intimidate did implicate the power balance. Now, in the current law, we see bullying as defined as an act that is direct or indirect and severe, persistent, or pervasive that causes physical or emotional harm, a fear for emotional or physical harm, or infringes on the rights of a student in the school environment. That is quite general, and in fact raised questions as to whether in fact teachers could be accused of bullying. And this new definition restores that notion of power imbalance among students. And you see here that bullying is defined as unwanted and aggressive behavior among children in grades K through 12 that involves a real or perceived power imbalance. But the new law asks to start at a lower stage, and rather than going right to whether bullying conduct has occurred, there's a new concept of challenging behavior, which triggers the obligation to intervene. And challenging behavior is by statute defined as behavior that negatively impacts school climate or interferes or is at risk of interfering with the learning or safety of a student or the safety of a school employee. So the new approach here is to focus first on the challenging behavior, and then through a tiered intervention, deal with that behavior and hopefully address it successfully before it evolves into bullying behavior. So the statute redefines roles. We have the school climate coordinator. It used to be the safe school climate coordinator. That would be the superintendent or a designee who is responsible for oversight on this process to develop strategies to prevent, identify, and respond to challenging behavior, communicates those strategies to the school community, and maintains data on that. But these interventions are focused at the school level. and we see that each school will have a school climate specialist similar to the current Safe School Climate Specialist. And the school climate specialist has significant new responsibilities. They're not charged in the first instance for investigating bullying, but rather they are to lead in the prevention, identification, and response to challenging behavior. And they're responsible for overseeing the meetings of a new entity, which is the School Climate Committee, which is described as follows. It has to be, the school climate coordinator does, school climate, specialist appoints this committee. This committee is to be composed of members who are racially, culturally, and linguistically diverse and representative of the various roles in the school community. The School Climate Committee is responsible for many things, including the assisting of the development, scheduling, and administration of a school climate survey that has to be administered every 2 years. And that's going to be important information for going forward to developing the school climate plan. And interestingly, there is an opt-out provision in the statute for parents who don't want their students to participate in the survey. There are also, in the school climate improvement plan, every school must have that, and it has to be shared with the community, and it has to be updated on an annual basis. And the school climate improvement plan has to take into consideration the factors listed here, the results of the survey, recommendations from the committee, and other data. Now, this is all a procedural structure. The meat and bones won't come until we have the school climate policy and further guidance. But this is a significant change coming down the pike, and we wanted to bring it to your attention. There are new training requirements under the statute, as are listed here, and the training starting next year must provide resources on social emotional learning, school climate and culture, and evidence-based interventions, including but not limited to restorative practices. More about that in a minute. And any school employee is entitled to participate in this training. And as a related matter, boards of education are required to adopt a restorative practices response policy starting actually July 1, 2025. And that's to guide school employees in intervening in incidents of challenging behavior or student conflict, but only if it's nonviolent and doesn't constitute a crime. There's a whole separate way to approach violent behavior, and Dori will speak to that momentarily. And if I just to finish up with my brief part here, going with the new law, right now, boards of ed, and for years and years, boards of ed have been required to have a policy on youth suicide prevention. And as I've worked with districts over the years, I've always advised them, and it's you can never think about this too much, how important it is not to overpromise in these policies, but rather to adopt policies that are manageable. Because when you adopt a policy, you're establishing the standard of care. And then if you adopt a policy that people don't follow because it's too ambitious, then you're creating a risk of liability because someone later will claim you didn't do what you promised. So as you look at these, your suicide policy, do keep in mind the importance to be practical and realistic. And in this new law, we have further guidance that the policy must address the risk factors for youth suicide based on statewide strategic school prevention plan developed by the Connecticut Suicide Advisory Board. And there are minimum requirements to address concerns about students who are bereaved by suicide, who are disabled or have chronic health conditions, who are involved in the juvenile justice system, who are experiencing homelessness or placed in an out-of-home setting, such as foster care, or who are lesbian, gay, bisexual, transgender, or questioning. These are groups of students who are identified as at particular risk that should be addressed through your policy. And the development of the revised policies can include use of an assessment recommended by the State Department of Education, and the assessment that you choose but must be approved by the State Department of Ed would help determine the risk for students who exhibit mental health distress, who have been identified at risk, or who are considered to be at increased risk based on those risk factors. When students are so identified in accordance with these revised policies, they're supposed to receive, quote, heightened consideration. And that's where you have to be careful exactly what you're going to do in these circumstances. And to move on, the last point I wanted to make before I turn this over to Dori is that given the requirement for these new assessments, the state is now required to provide Medicare reimbursement for these assessments and other mental health evaluations and services provided at school-based health centers or public schools. So that's quite a bit, and that's just the beginning. Now I'll turn it over to Dori, who will speak to a number of other new requirements. Thank you, Dori.
Thank you, Tom, and good morning, everyone. Thank you for joining us this morning. We have a lot to cover, so thanks for sticking with us. The first thing that I'm going to talk about today are SRO MOUs. Those are short for School Resource Officer Memorandums of Understanding. So pursuant to state statute, every Board of Education that assigns a school resource officer to its schools must have a memorandum of understanding with that SRO's local law enforcement agency, outlining the SRO's role and responsibility in the school. And that's been a requirement for some time. For some time, the law has also required various issues to be addressed in the SRO MOUs, such as the implementation of a graduated response model, so that generally school discipline is handled by teachers and administrators in the school and not the SROs. In 2021, you might remember that the law was revised to add the requirement that SROs also complete any separate training specifically related to social emotional learning and restorative practices that's made available for certified employees in this district. This year, the legislature made additional and significant revisions to what's required to be addressed in SRO MOUs. So the first new requirement is that the MOU has to be made available to the public. It has to be maintained in a central location in the school district, and it has to be posted on the school district's website, as well as the website of each school in which SROs are assigned. The second change really is to the substance of the MOU itself. And the new law provides that any agreements that are entered into, extended, or amended on or after July 1, 2023, so that's now currently in force, anything that changes, any agreements that change from this point forward, must address some new requirements. And those include the SRO's duties concerning and procedures for the restraint of students, the use of firearms, school-based arrests, and just a warning, this next part's a mouthful, reporting of any investigations and behavioral interventions of challenging behavior or conflict that escalate to violence or constitute a crime. That last part is really important. So we're talking about reporting requirements for when an SRO conducts an investigation or intervention that ultimately escalates to violence or criminal behavior. Importantly, the new law defines the investigations or behavioral interventions subject to the reporting requirement as those conducted by a school resource officer, so not those that are conducted by administrators. And those can include fact-finding inquiries concerning student behavior or school safety, including but not limited to something that happens in an emergency circumstance, or an intervention to resolve violent or non-violent student behavior or conflicts. But again, This reporting requirement only kicks in when it rises to a level of violence or criminal behavior. The new law also details the information that SROs must provide in these reports, and it's very detailed. The reports must include the date, the time, and the location of the investigation or behavioral intervention that is conducted by the SRO, the name and the badge number of the SRO, quite a bit of demographic information, including the race, ethnicity, gender, age, and disability status of each student who's involved. Importantly, you do not include, the SRO should not be included student names in these reports, but should include this other information. The report also has to include the reason for and the nature and disposition of the investigation or the behavioral intervention, as well as an indication of whether any of the students involved was searched by the SRO, informed of their constitutional rights, issued a citation or a summons, arrested or detained, and the length of any period of detainment. Okay, so the new law also addresses, so the new law talks about everything that has to be contained in the report. It also addresses when and to whom these reports must be submitted. Specifically, the SRO must submit the reports to their chief of police no later than 5 school days after conducting the investigation or behavioral intervention of challenging behavior or conflict that does escalate to violence or constitutes a crime. It's also important to note that once the chief of police receives these reports, the chief of police has to submit the reports back to the superintendent on at least a monthly basis. And then in turn, when the superintendent has these reports, the superintendent is charged with submitting the reports to the Board of Education, although there's no prescribed schedule for doing so under the statute. Some important things that we want to remind school districts to keep in mind when implementing these new requirements. The new SRO reporting requirements are effective immediately, even though they only need to be addressed in the agreements that are entered into, extended, or updated after July 1st, 2023. And this is a really important one, that given the sensitive nature of the information being shared, it's important to have a very clear understanding with local law enforcement agencies about when and what to report, what documentation and form should be used, and how to meet all of these new statutory requirements and still meet your obligations to comply with FERPA and protect confidential student information. We recommend too that similar thought should be given regarding when and how to submit the reports to the board in light of FERPA and the potential for disclosure of PII, which would be a fact-specific analysis, as are most things under the law. And careful consideration should also be given to the law's other new requirements and provisions regarding restraint of students, use of firearms, and school-based arrests. Okay, so that was enough about SROs. We're going to move on to some facilities issues right now. And the first one is school indoor air quality. So for quite some time, state law has required boards of education to conduct indoor air quality inspections every 3 years for any school building that was constructed, renovated, or replaced on or after January 1st, 2003. Beginning January 1st of next year, so beginning January 1st, 2024, there are some changes. Boards must, as of that date, provide for uniform indoor air quality inspections and evaluations within each school building on an annual basis and using a specific assessment, which is the Environmental Protection Agency Air Quality Tools for Schools program. Existing law that's unchanged by this new public act identifies myriad areas that the inspection or evaluation must address and requires that the results be made available at a regularly scheduled board meeting. The boards of education are also, under the statute, required to post the results on the board's website and each school's website, if any. In addition to these indoor air quality requirements, boards of education have requirements for HVAC inspections and evaluations. Current law requires boards of education to conduct these inspections and evaluations, and they have to be conducted by a certified technician, industrial hygienist, or mechanical engineer. They have to be conducted within each of their school district school buildings every 5 years and in accordance with statutory standards, which are which are pretty involved and would probably take up 2 slides. So we haven't included all those standards here. The new law extends the deadline for completing these inspections and evaluations to January 1st, 2025. It also provides for a new waiver process if the Department of Administrative Services finds that there's an insufficient number of certified individuals who can perform the inspections and evaluations, maybe because they're busy all over the state performing them in accordance with the law. So there's a waiver process if you can't find someone qualified to conduct it. Or if the board has scheduled this type of inspection and evaluation for a date after January 1st, 2025. But importantly, the waiver isn't forever, and any waivers that are granted will only be valid for 1 year. I will just want to make a couple additional notes that as to both indoor air quality and HVAC evaluations, under the new law, the Department of Administrative Services is tasked with developing standard reporting forms that boards of education will have to use. And maybe some good news here. We always get questions about unfunded mandates. These are unfunded mandates, but at least as to HVAC inspections and evaluations, there is some funding available to help districts with the costs. In 2022, the state established a grant program to encourage public school districts to install, replace, or upgrade their HVAC systems. And according to the state's website, the application for the next fiscal year, these grant applications, it's now open. They're due by December 31st of this year, with awards being announced next spring. One other related note that arose at the beginning of the year when we had our heat wave, a lot of schools were asking, kind of related to HVAC and indoor air quality and all those types of things, is there a temperature at which districts must close or implement early dismissal? There is nothing in the statute that says once it's a certain temperature outside or inside, you have to close school. But this past legislative session, the legislature did address school building temperatures by directing the Department of Public Health to develop guidelines by July 1st of next year on the optimal temperature comfort range, which will be 65 to 80 degrees for school buildings and facilities, with a larger kind of spectrum of acceptable temperatures for gymnasiums and swimming pools. Okay, so that's it for facilities issues. We're going to move on to special education. I will just say at the outset, there's a lot of very detailed information here. So if you stick with us for a little bit, that'll be great. We just wanted to flag some of these for you, but more information, as Tom mentioned, is available on our legislative update. The biggest change to special education, I would say, is something I think that most districts are aware of, and it concerns the age for eligibility. Last year, to conform state law to a recent court decision, the General Assembly required boards of education to provide special education services to eligible students until they reach the age of 22 rather than 21. This year, the legislature made another change, and state statute now provides that students remain eligible for special education services under the IDEA through the end of the school year during which they turn 22, or until they graduate from high school with a regular high school diploma, whichever occurs first. Okay, the next few slides, we are going to focus on transition services. And as you may be aware, transition services were a hot topic for the legislature this past session, and there are many new and revised requirements relating to transition services. So from a statewide perspective, the legislature directed the State Department of Education to now employ a statewide transition services coordinator, as well as an assistant transition services coordinator within the Bureau of Special Education. The statewide coordinator has numerous duties under the law, but there are two that we wanted to point out in today's talk. One is that the statewide coordinator is responsible for performing unannounced site visits of public transition programs to determine their effectiveness and to suggest improvements. And they're also charged with developing a training course for educators and staff who do not provide transition services to inform them about transition services and programs. So the new law does not only mandate that there be a statewide transition coordinator, it also says that boards of education must specifically designate a district transition coordinator. This role can be filled by a current employee and will likely in most districts be the director of pupil personnel or a similar staff member. And as we'll discuss in the next few slides, there are numerous new requirements, specifically about information that must be provided regarding transition services for eligible students. And the district transition coordinator has to facilitate the sharing of information. The law also requires the State Department of Education to develop a training program for district transition coordinators by July 1st of next year. And the district transition coordinator has to complete the training within 3 years of the program commencing or within 1 year of hire if hired after it commences. Transition program training programs. So that same training program I just spoke about must also be completed by educators and school paraprofessionals who provide special education students for students aged 14 and older. Staff members who are not the district coordinator have a bit more time to complete the training, and they have to do so within 5 years of the program commencing or within 1 year if hired after it commences. Importantly, each RESC is required to provide the training at no cost. And in addition, there's another training program that's to be developed by the Bureau of Special Education by July 1st of next year and then annually updated. That training has to address legal requirements and best practice recommendations for special education and transition services. Interestingly, the law does not mandate any specific employee take this training, but that could change over time. So we'll see how that develops. Okay, in addition to all these new training requirements, the legislature also mandated the creation of new transition program resources. And the statewide transition services coordinator that we spoke about at the beginning must create and post a list of transition resources, services, and programs, and provide this list to boards of education. In turn, the school districts have to distribute the notice to parents at PPT meetings for students in grades 6 through 12. There's other information that has to be provided now at PPT meetings. So just a couple more things about transition services, and then I promise we'll move on. So as we just noted, the legislature was very concerned with ensuring that parents be provided information about transition programs and that the information be presented in a way that all parents can understand. So now at the first PPT meeting, after a student turns 14 and has a statement of transition service needs included in their IEP, the PPT must provide the parent with a listing of each public transition program, each adult program for which that student might be eligible after graduation. And they have to include a plain language description of the program, the eligibility requirements, and the deadlines and instructions for application. In addition, with and upon approval of the parent, the PPT has to notify the state agency that provides any such program about the potential eligibility of that student. And in a similar vein, the PPT meeting that occurs approximately 2 years before a student's anticipated exit from the district. At that meeting, the PPT must provide each parent with a listing of the adult programs for which the child might be eligible, a plain language description of the program, the eligibility requirements and deadlines and instructions for application. Again, upon parent approval, the PPT must also notify the state agency about the student's potential eligibility, invite an agency representative to the PPT meeting, and permit and facilitate contact between the agency and the parent. The PPT is also charged with assisting the parent in completing any applications to the program. So there's a lot of new requirements, a lot of new information sharing that has to happen at PPT and otherwise. And the purpose of these requirements is really to permit and facilitate contact and coordination between the state agencies and the parent or guardian to ease this process of transfer of services post-graduation. Just a couple more things about information to parents regarding special education. There's another requirement that's specific to students who are 14 and older. The new law requires that at the first PPT meeting after the student reaches the age of 14, the PPT must provide the student and the parent with information on the full range of decision-making supports, because as you can guess, these are important decisions that have very monumental effects and ramifications for the child. And those supports need to include alternatives to guardianship and conservatorship. They also have to provide the parent and the student with plain language online resource that's to be developed by the State Department of Education by next summer, by July 1st of next summer. And once the student, it's not a one-time only requirement, once the student reaches the age of 14, this does become an annual requirement. So Thank you for sticking with me for that detailed overview of the new requirements as related to special education. As I said, there's more information in our summary online, and I'm going to hand it over now to Tom. We'll cover some additional changes in the special education arena. So there you go, Tom.
Well, thank you, Dori. Yes, there are a number of additional special ed requirements. The General Assembly spent quite a bit of time on special education issues in its legislation. Another change in the law is that we see Public Act 23-137 now requires that boards of ed provide interpreters and translated documents to students and parents when there's an apparent need or upon request. And I'd like to pause there because that's, I think, highly significant and a risk that this new legislation introduces. There's other legislation this year about a multi-language learner Bill of Rights, and multi-language learners and their parents now have the right to request translation services during critical interactions between school administrators and students and their parents. They also have the right to request translation services for boards of education meetings. But this statute says upon request or when there is an apparent need. So your staff needs to be sensitive to the fact that this is an affirmative obligation. We don't just wait for someone to ask for translation services. We need to have our eyes open and consider whether the circumstances presented suggest a need for translation services. And we need to address that one way or the other directly. And we should probably make note in the PPT minutes of that particular decision, because the concern here is that you go forward, there's no request for translation services, you come up with an IEP, everything's fine, and 6 months later, the parent who is a multilingual person says, well, I didn't really understand what happened at the PPT, and no one asked me if I needed translation services. So given that, now this is the lawyer talking, given that parent participation is critical to the procedural rights and the development of IEPs, that IEP is suspect and should be discarded, and we need to start over. So we need to be very vigilant in determining whether there's a quote apparent need and addressing that issue specifically through the PPT process. There are other changes in the law about special ed, coming at this originally from a labor relations standpoint. I love mediation. Mediation is great. Any kind of dispute resolution should always be based on interests, not positions. And so the state, through the General Assembly, has recognized the advantages of expanding mediation to address disputes early and effectively. Now the State Department of Education is required to employ a mediation service coordinator, and parents are entitled to request mediation through that coordinator at any time for any matter related to the provision of special education for a child, including but not limited to identification, evaluation, placement, or implementation. So this is a new focus on mediation that I think is welcome, and we should just be aware of that. Now, I hope the next slide doesn't affect any or many of you, and that is the dreaded due process hearing, when mediation is unsuccessful and there's a dispute that needs to be resolved through a formal adjudication in a due process hearing. The typical approach is that the person with the complaint goes first. And there were stories about parents being on the stand talking through their lawyers, talking about procedures for 2 or 3 days before we even heard about the student. And so this new law reverses the presumption. And even when a parent has requested a due process hearing, the Board of Education is required to present its testimony first. That is consistent with normal legal process, because under Connecticut law, as opposed to the IDEA more generally, under Connecticut law, the burden of proof is on the school district to show that the IEP is appropriate. So now, because of that burden, the school district goes first, and in the rare circumstance where a due process hearing is necessary, I think it's a welcome change, because the district can provide a organized accounting of exactly what went into the IEP and why the school district thinks it's appropriate. So that's another good change. There's always concern about the participation of parents in the process, whether it's multi-language learners or parents of children with special needs. And we've long had requirements for providing information from parents. Now there are new requirements. We're supposed to provide the plain language resources developed by the State Board of Education concerning the hearing and appeals process. We're supposed to provide information regarding free and low-cost legal assistance, and districts are supposed to provide the Parent's Guide to Special Education. So these are new requirements for sharing information about special education needs. And similarly, as we see on the next slide, or this slide, the State Department of Education is required by this coming January 1st. By the way, I hope the State Department of Education gets some good funding to hire all these people and do all these things every year. The State Department of Education is tasked with new responsibilities. One of them is to develop by January 1st an informational handout for students explaining what it means to have an IEP and or a Section 504 plan. This handout has to be provided to students with an IEP or Section 504 plan at the beginning of each school year. The districts must also provide the Parent's Guide to Special Education and rights and resources available to children in the provision of special ed services. So we have those new requirements as we.
Tom,
oh, please.
Sorry, can I stop you for a second? We have a question about if the documents for each PPT have to be in paper form, or can links be provided?
That's a detail. I'll answer the question, but with a caveat that's quite specific, and I can't say this for sure. But I think that the translation services can be provided through other means, but the documents themselves will be part of the record, and I would expect that there should be a translated document, because that would be evidence that the statutory requirement has been fulfilled. But that's just my best answer on the spot, and we can follow up with Karen and Tiffany so that when you get further information about this, we can answer that question. And anything else, Tiffany, at this point? No. Okay, then
That's it so far.
Okay, just to finish up with the special ed piece, there's the next slide. We see that the State Department of Ed, yet another new responsibility, is required to conduct audits of special ed programs in randomly selected districts each year. And we see that the audit has to include interviews of teachers, staff, and parents of children requiring special ed, includes unannounced on-site visits to observe classroom practices and review of IEPs. This is logical in the sense that under the IDEA, the federal funds are given to the state, and the state administers the Part B funds and allocates them to the individual school districts based on compliance with statutory standards. So these audits would be a way to assure that that's happening. Now, if you're if you've had enough about special education, we'll move on to some new and different requirements under the law. We all remember the pandemic and the challenges that it confronted and it imposed upon us. And dual instruction was one of those challenges where we were expecting teachers to instruct children who were sitting in front of them and children who were remote. And just as a personal anecdote, I teach school law, and at Quinnipiac, I had to do that in a mask with students remote, students in front of me. And so my heart goes out to teachers who had to do that as well. And so last year, in response to legitimate concerns, the General Assembly prohibited dual instruction. Quickly, though, we all realized that a blanket prohibition would have unintended consequences and would interfere with the ability of school districts to accommodate the needs of children with disabilities who may, for example, be immunocompromised and who may not always be able to attend in person. And so the State Department of Education, about a year ago now, came out with further guidance and saying, yeah, we know what the law says, but we have to read it in a manner consistent with our other obligations. And so accommodations are allowed. And in fact, collaborative programs to provide courses to students in low enrollment subjects is also permitted under the law. And that was the guidance that preceded this legislative change. In the last session, the General Assembly codified those two exceptions and expressly said that, notwithstanding the general prohibition of dual instruction, school districts remain free and indeed obligated to provide dual instruction when it's necessary to implement a student's IEP or Section 504 plan. And then as to the other area in which dual instruction may well be advisable, that is, like you want to teach Mandarin and you don't have enough students to take Mandarin in a particular school, in other schools in the district or in other schools in other districts, you can combine those students interested in this low enrollment course and provide that instruction through dual instruction and remote learning. That particular approach, though, does require a memorandum of understanding between the local teachers union and the Board of Ed, laying out the ways in which those programs would work. However, the statute itself is prescriptive in the sense that it does require that in both classrooms a certified staff member be present. It doesn't require that the certified staff member in each of those classrooms be teaching, but a certified staff member must be present. So that could be in some of those classrooms an extra duty assignment. The last thing I'll say about this is I think teacher unions are understandably cautious about arrangements for education to be provided remotely as a matter of job security. And those teacher unions may be unwilling to enter into a memorandum of understanding on the subject. However, the statute makes it a mandatory subject of bargaining, and we have in the Teacher Negotiation Act a procedure for midterm bargaining. So school districts will have to decide whether it's important, and teacher unions will have to decide what their position will be. But there is a procedure in the statute for resolving any impasse that may arise over that. The next new requirement, we've long been required at boards of education to adopt minority educator recruitment plans. The new law changes the name of these required plans to increasing educator diversity plans. And now these plans have to be submitted to the State Department of Education for its approval. But this is where we'd like to offer another caution, and that is that people of goodwill look at the problem of diversity and say, well, how do we increase diversity? Well, we should identify people by their diverse status and give them encouragement and advantage in the hiring process. Now, I will say that outreach, minority recruiting fairs, those are all fine, but we have to be very careful about adopting any standards that create preferences based on race, given the actions of the United States Supreme Court, most recently in a case involving Harvard University, where their admissions processes were struck down because in the court's view, those admission processes gave advantage on the basis of race to certain groups, and thereby violated the constitutional imperative for equal protection. And this has long been established that any classifications based on race are subject to the highest standard of review, which we call strict scrutiny. And any classification based on race can be justified only if there's a compelling governmental interest and the preference or determination based on race is narrowly tailored to address that compelling state interest and no more. But the Harvard case indicates that this court is highly skeptical. And there's, of course, both sides of the story, and there was a significant dissent in this case, as there has been over the years between the two schools of thought, whether we can take affirmative steps to provide advantage to promote diversity. But this court has said no by a majority, and we need to be very careful. Now, the boards of ed are to submit their plans to the State Department of Education, and the State Department of Education may write back and say not good enough and suggest changes, and that could be an iterative process back and forth. But it'll be very interesting to see how in this process the State Department of Education addresses the constitutional issues that I've just described in terms of their expectations for how these plans will work. And starting next year, boards of ed have to implement their approved plans and post them on their websites. The teacher shortage, which continues, is a continuing source of attention and concern. And new legislation now requires by January 1st of the coming year that boards of ed develop an exit survey to be completed by teachers and who voluntarily cease employment. In speaking on this topic another time, I was asked the question, well, what if someone's up for non-renewal and we give them the chance to resign instead of get non-renewed? Would that be considered a voluntary cessation of employment, and should they have to fill out this exit survey? And the answer is no. In those circumstances where a person is encouraged to resign employment at the risk of being non-renewed or fired, we don't consider that to be a voluntary resignation. And that has implications for unemployment compensation. It's not a voluntary quit, but it also has implications here. So we would we would implement this survey only for people who truly leave the district voluntarily. And the exit survey has to include questions on why the teacher is ceasing employment with that district, whether the teacher is leaving the profession, the demographics of the teacher, and the subject areas that the teacher taught. This is an evolving issue. One concern we have as employers, we represent the board, is that people are going to wax poetic about how bad things are in a particular district, and it's going to be a public relations issue because these the results of these surveys have to be posted on the strategic school profiles. So as we develop these surveys, we might want to find ways to get the necessary information without inviting an opus on what's wrong with a particular school district. So we just have a couple more issues for me to address before we turn it back over to Dori. And the law is now changed so that a substitute teacher can be in the same assignment for up to 60 days without obtaining a State Department of Ed substitute authorization. There's an interesting interplay between this new law, which just gives school districts more flexibility, and a different law and regulation regarding certification that says if a teacher is in the same assignment for more than 40 days, they need to have certification. So we have these two situations where one's a non-certified person, they're a substitute, they can be in the same assignment for up to 60 days. But if the individual has a certificate and they're in a position requiring a certificate for more than 40 days, that's still the law. That individual becomes a member of the teacher's bargaining unit. They're covered by the tenure law. Well, actually, they're not covered by the tenure law until they've worked for 90 days. But it's a different circumstance. If the person filling in has a certificate, the other law applies. This is for people who don't have a certificate, in fact, don't even have a substitute authorization. They can stay in the same assignment for up to 60 days. Then the last thing that I'll be speaking on during this section of the presentation is teacher performance and evaluations. This is another area of the law that is very positive development. Back in 2012, so that's now 11 years ago, there was through educational reform, the tenure law was revised so that teachers could be held accountable for not only inefficiency or incompetence, but a new standard of ineffectiveness. And that new standard of ineffectiveness was to be determined in accordance with the teacher evaluation system. And only if the procedural requirements of that teacher evaluation system were carefully followed, only if that determination was made in good faith, and only if that determination was reasonable in light of the evidence. But if those standards were met, then teachers were subject to termination based on ineffectiveness. The problem was that those provisions in the law invited complexity, because the more complicated a process, the more difficult it would be to hold a teacher accountable for ineffectiveness. And so we have a new opportunity to take a look at the teacher evaluation plan program. Teacher evaluation and support program is how the statute defines it. And by July 1, 2024, all school districts are going to be required to adopt a new teacher evaluation and support program in accordance with the guidelines of the State Department of Education, actually the State Board of Ed, which adopted those guidelines, and they're out. So now school employees and boards of education can work together to come up with a new plan. The new plan offers opportunities for making things simpler. It removes the requirement that all teachers be placed in one of 4 categories of exemplary, proficient, developing, or below standard. It removes the scoring systems. We no longer have to do math to determine whether a teacher is meeting standards. And the guidelines, the statute requires that the guidelines use multiple indicators of student learning, growth, and achievement rather than student academic growth and development in the evaluation process. The State Department of Education is still, we're still waiting for the model teacher evaluation and support program that it must develop that can be used by boards of education. And that model program will be very important because the process for adopting a teacher evaluation and support program has carried over from the current law. There are no changes, but it's important to be aware of how this law works. And in the first instance, we expect the professional development and evaluation committees, which each school district by law must have, to take the lead in developing a new teacher evaluation system. This is where it's important that we not indulge in complexity, that these plans be more flexible. We can't have procedural violations if someone gets sick and they're 2 days late and giving feedback. So it's a critical stage we're in now without a lot of time. But in the first instance, the PDEC, the Professional Development and Evaluation Committee, and the Board of Education may develop that plan through mutual agreement. Interestingly, the PDEC doesn't adopt the plan. The statute talks about the PDEC participating in the development of the plan. The Board of Ed adopts the plan, but the development can be by mutual agreement, and the board can then go ahead and adopt that plan that was developed by mutual agreement. However, if the Board of Ed is not able to reach an agreement with the PDEC on the terms of the new teacher evaluation plan, then both the PDEC and the Board of Education must consider that model program, which then they may adopt by mutual agreement, which then the board would adopt. And so we're very curious to see how this model teacher evaluation program will roll out, and we're hopeful that it will take heed of the need to be flexible and not overly rigid, but that remains to be seen. If the parties look at that model teacher evaluation program and are happy with it, then that may be the answer. However, ultimately, the Board of Education has the authority to adopt a plan it believes appropriate, as long as it's consistent with the guidelines, which, as I mentioned, just came out. So we have this 3-step process: mutual agreement. If that doesn't work, then we look at the state model. If that doesn't work, then the Board of Ed has the unilateral right to adopt the new teacher evaluation support program, provided that it's consistent with state Board of Education guidelines. And I think that gets me through my section here. Oh, the last thing, and thank you, Dori, and that there are training requirements, and these training requirements must now be implemented starting with the current school year, annually, not biannually. And this training is important because as we move forward through this process of new process of teacher evaluation, it's important that teachers understand the process by which they will be evaluated, and administrators understand the process by which they will be doing that part of their jobs. Everyone needs to be aware of how this new system is going to work, and school districts have a lot of work to do between now and July 1. And I'll turn it over to Dori.
All right. Thank you so much, Tom, for all of your insight and your historical perspective on so many of the new changes too. I know I always learn a lot from listening to you. All right, we're going to turn now from employment related issues to some student related issues. And I know this next one is something that everybody's aware of, but we're going to just talk about it just to go over what the new law requires. So currently for this school year, state law requires that children be at least 5 on or before January 1st of the school year in order to enroll in kindergarten. So beginning next year, so for the 24-25 school year, state law has been revised to state that children must turn 5 years old on or before September 1 of the school year in order to enroll in kindergarten, so that our incoming class will be older, right, and more ready for the kindergarten curriculum and program. There is an important exception that's written into the law and also effective July 1st, 2024. So for next year, a child who is not 5 years old on or before September 1st of the school year can still be admitted, but there's 2 prongs that have to be met. First, there has to be a written request by the child's parent or guardian that is submitted to the school principal. And then there has the school principal and an appropriate certified staff member have to conduct an assessment of the child to determine whether admitting the child to kindergarten is developmentally appropriate. So we have received a number of questions regarding, first, whether a school district must provide for an assessment process at all, or if they can just decline to engage in the process. And if they do, what that assessment process should entail. So as to the first question, we read the statute and we understand that the State Department of Education's position is that school districts are required as of next year to have some type of process in place by which the parents or guardians of a child can request early admission to kindergarten. And upon receipt of that written request, the district performs an assessment to determine whether enrolling the child in kindergarten early is developmentally appropriate for that child. So in other words, that's the first question. Districts cannot simply decline to consider the request or engage in the process at all. So that leaves the second question, which is, what will this assessment process look like? What does it have to look like? The State Department of Education has provided some guidance about the new law generally. They provided initial guidance in July and updated guidance in August. We've reached out to the state to determine if there will be additional guidance and or a sample assessment or inventory for purposes of complying with the new law. We understand that the State Department of Education will be reaching out to stakeholders to get more input on the practical issues involved in implementing the new law, and that additional guidance may be forthcoming. So we will stay tuned on this. One thing I just want to mention, and then I'll
okay, go ahead.
Just one thing, and then I just do want to say, and we want to make sure that districts are aware whether or not additional guidance or some kind of sample assessment is provided. Districts have to keep in mind their obligation to ensure equal protection, right? And ensure that they're implementing the assessment process in a way that similarly situated students and families are treated in the same way. So go ahead, Tiffany. I know this has been a hot topic.
Yeah, it has been. So 2 things. One, there's a question about the assessment, but am I correct in saying that schools are allowed to use the assessment they choose at this point to determine eligibility?
At this point, there is no specific indication of a particular assessment that has to be used, although we don't know. We will see if there's more guidance coming out from the state, but as it stands right now, there has to be an assessment for this process, and there's no particular assessment that must be used.
Okay. And then question, does the law include anything about pre-K to K gap year now that many might be starting later?
There's nothing in the law. There's nothing in the revised statute that addresses it. I do know that the Office of Early Childhood and the State Department of Education in their joint guidance addressed this topic, because there is, how should preschool programs handle kids who might be in preschool an extra year or and things like that. But there's no statutory requirement of what school districts have to do in order to address those students.
Great. Thank you. That's it for questions. Oh, one more. Sure. When do they recommend these requests for early admission take place in order to meet the assessment component?
So far, that's an unanswered question, and that would be up to the district in terms of when, even in terms of how to notify families that there is a process in place. We're hopeful that we're going to get more guidance from the State Department of Education on this, but as of yet, it's an open-ended process, and certainly would have to be during that registration process so that the school district can plan for the incoming class, but there's no date certain by which it has to be provided or after which it has to be provided.
Thank you.
Yep. Tom, did you want to weigh in on this at all? I know it's a hot topic. I know you love hot topics.
You did great. I have
Okay.
nothing further to add.
All right. Okay, so we are going to move on to some more things at the early end of the student spectrum, which is play-based learning. This is another change to the law, which goes into effect next year. So as of July 1st, 2024, boards of education must provide play-based learning during the instructional time of each regular school day. And that's for students attending kindergarten and any preschool program offered by the board. The law states that the play-based learning must be integrated into daily practice. So that's right in the statute. It has to allow for student needs to be met through free play, guided play, and games. And it has to be predominantly free from the use of mobile electronic devices. I think we all saw enough of the screens, right, during the pandemic and post-pandemic. So this play-based learning has to be predominantly free from the use of screens. The new law also says that boards of education, in addition to including the play-based learning in the kindergarten and preschool program on a daily basis, boards of education must allow a teacher to use play-based learning during the instructional time of a regular school day for older kids, for students in grades 1 to 5. And the new law adds a play-based learning requirement to the professional development requirements for teachers in a preschool program or grades K-5. And that also begins next summer, July 1st, 2024, when the play-based learning has to be implemented. And that new requirement, that PD requirement, expands the existing requirement that educator PD focus on refining and improving effective teaching methods. So what is play-based learning? Play-based learning is defined in the statute as a pedagogical approach that emphasizes play in promoting learning and includes developmentally appropriate strategies that can be integrated with existing learning standards. So as Tiffany mentioned at the beginning, I'm a former kindergarten teacher. I think of this as controlled chaos. And I think probably most pre-K and K teachers are familiar with this type of learning. Importantly, this term does not mean and does not encompass any time that's spent in recess or part of the physical education program. The statute also provides, and it's a good reminder, that any play-based learning must also comply with a particular student's IEP or their Section 504 plan. And as another reminder, boards of education are required to adopt policies addressing the withholding of undirected play periods as a form of discipline. And school employees who are engaged or offering play-based learning in their classrooms can only prevent or restrict a student's participation in that play-based learning in accordance with the board policy on this topic. So that's another important thing to keep in mind. Okay, so we're going to move on from the early years of a student's K-12 education to the end of their K-12 education, where the legislature also made changes to existing statutory requirements, specifically as related to new and revised graduation requirements. So as you likely know, state law outlines the high school graduation requirements throughout the state, and boards of education must develop policies that either meet or exceed these requirements. So there were several changes this past legislative session, some of which go into effect this year and others go into effect over future years. And so we'll walk through those so that you're aware of them. The first is that for classes graduating in 2024 and beyond, so that's this year, the legislature actually introduced some flexibility for boards of education and revised state law to state that boards of education may, but they are not required to require graduating students to complete a 1-credit mastery-based diploma assessment in order to graduate from high school. So as I mentioned earlier, boards of education did not have this discretion previously when the mastery-based diploma assessment was first added as a graduation requirement, because it was required for all students, but now boards of education have the flexibility to determine whether they would like to include that as a graduation requirement for their students. The second change, and we have a little bit of time for this one because this begins with the classes graduating in 2025. under the new and revised statute, graduating students must have done one of three things when it comes to completing a FAFSA, which is a free application for financial student assistance. They either have to have completed a FAFSA in order to graduate, or completed or submitted to a public institution of higher education an application for institutional financial aid for students that do not have legal immigration status, or they have to complete a waiver that's either signed by the student's parent or the guardian, or signed by the student themselves if they're 18 or over, saying we choose not to fill out these financial forms. So this is a new graduation requirement, and I think the legislature was mindful that they don't want to prevent or prohibit anyone from graduating from high school simply for failure to submit this financial information. So the law was revised shortly after it was written to include another waiver process or waiver opportunity. And the law states that on and after March 15th of each school year, so you have to give families and students the opportunity to complete the FAFSA on their own. If they don't, then a principal, a school counselor, teacher, or other certified educator can complete the waiver on behalf of the student who hasn't satisfied one of the requirements, one of the three requirements we talked about earlier. The caveat to that is that the certified professional has to affirm that they've made a good faith effort to contact the parent, the legal guardian, or the student about the completion of these applications. So that there's kind of two waiver processes that are available. One for the student or their parent or guardian to fulfill themselves, or two for a certified professional to do it on behalf of the family, as long as they've made a good faith effort to contact them about these requirements. These waiver processes are likely meant to ensure that students whose families who don't want to submit their financial information or a waiver are not prohibited from graduating, which I think is a good thing. The next change is a few years out, and it's for classes graduating in 2027 and beyond, and it concerns personal financial management and financial literacy. The new law requires that for students in these graduating classes, they must complete a 1/2 credit in personal financial management and financial literacy. That credit can count towards the 9 credits required in the humanities, or it can count as an elective credit, whatever the board decides to do in their graduation requirement policy. Just a couple more related notes. The legislature also revised the state statute that addresses the required program of instruction. So personal financial management and financial literacy have been added to the list of required instruction, which makes sense given the new graduation requirements. The new law also requires that beginning in the 25-26 school year, that civics and media literacy be added to the required social studies program of instruction. So the law defines civics as the study of the rights and obligations of citizens, and media literacy as the ability to access, analyze, evaluate, create, and participate with media in all forms by understanding the role of media in society and building skills of inquiry and self-expression essential to participation and collaboration in a democratic society. And I think we can all see why those are important skills for our graduating students to have. So those will be new requirements in the social studies program throughout the required program of instruction. Okay, it's a blank screen. Sorry about that. That blank screen is meant to say we're going to kind of do a lightning round now. We knew we had limited time, and as Tom mentioned at the beginning of this presentation, there are a significant number of changes.
Dori, can I stop you for 1 second?
Yeah.
We had one more question about financial, or a question about
Sure.
financial literacy.
Absolutely.
There wiggle room for it to be a STEM rather than humanities?
No, there's not. That STEM is a separate bucket of credits that are required, and so it can be a humanities credit or an elective, but not. The law does not provide for it to count as a STEM class.
Great, thank you.
Okay, sure. I'll just pause for a second in case there's any questions, but I'll watch for you to pop back on if you come back on. We're good. Okay. So I think we have about 10 minutes left. So as Tom mentioned at the beginning, there were a significant number of changes this legislative session, and we've covered a lot of them today, but not all of them. So please feel free to log on to our website for a comprehensive really kind of dense document with links to the public acts for those who want to read more. But because we have a bit of time left, we wanted to provide a lightning round and touch upon some additional changes that we couldn't cover in depth today. So I'll do the first few and then I'll hand it over to Tom. The first one is Title IX. And if you've been following federal changes to Title IX sexual harassment regulations, you know that changes to the federal rules are expected in the next few months. Connecticut is also adding new requirements related to Title IX. The legislature has directed the Commission on Women, Children, Seniors, and Equity to develop a Title IX compliance toolkit for school districts. And that toolkit is going to include a policy and training. The new toolkit has to be implemented by districts in the 25-26 school year. And in addition, beginning in the 26-27 school year, boards of education will be required to annually submit a Title IX compliance report to the State Department of Education. We are not sure what the toolkit or the compliance report will look like yet, and it might depend on how the rules change. But as noted, with respect to Title IX, we expect a lot of changes over the next year or so. So we will continue to monitor the changes, and we recommend that districts and certainly your Title IX coordinators be on the lookout for developments. There's also been significant changes regarding expanding opioid antagonist access that were put into place this year. So just to back up for a second, last year, the General Assembly revised state law regarding the administration of medication in schools to allow specified school personnel to maintain and administer opioid antagonists to students in emergency circumstances, provided certain requirements are met, and they're pretty extensive. Among other things, with the change in the law last year, boards of education were authorized to enter into agreements with prescribing practitioners and pharmacists as related to the distribution and administration of opioid antagonists like Narcan in order to address the reversal of an opioid overdose. The new law that changes effective this year specifies that those agreements can apply to intranasally, so medications administered through the nose, or orally administered opioid antagonists. The new law also answers a frequently asked question about how to store opioids in a way that they can be accessed outside of school hours. In other words, not locked in the nurse's office, where medications are usually stored. The new law states that agreements between prescribers and boards of ed can now permit boards to install a secure box containing the opioid antagonist on their premises. If your district is interested in doing that, you need to ensure that you know what all the requirements are, because the statute explains that the agreement that talks about the secure boxes must address environmental controls necessary to store the medication. It has to set procedures for replenishing the opioid antagonists, monitoring their expiration dates and disposing of them when it expires. And there's also required signage that has to disclose the presence and usage directions of such opioid antagonists in the languages spoken in the community. In addition to the option to have secure boxes on school grounds now, under the new law, boards of education and prescribers can also enter into an agreement to operate a vending machine that distributes intranasally administered opioid antagonists. There's a bunch of requirements too in terms of signage and what must be displayed on the outside of the box of the machine or in an area adjacent to it or upon distribution. And that information has to include signs and symptoms of an overdose, how to use the opioid antagonist, information on services to treat opioid use disorder, and a website or QRC code directing individuals to additional online information about overdose signs and symptoms, response, and how to use the opioid antagonists. One note I think that's important for boards to recognize is that boards of education can still adopt policies for the administration of opioid antagonists at school without maintaining secure boxes and vending machines. That's an additional option that boards can determine whether they want to undertake. And then one further note, we understand from working with a lot of clients that it can often be difficult to stock and maintain an adequate supply of opioid antagonists. So the new law did create an opioid antagonist bulk purchase fund, and the Department of Mental Health and Addiction Services not later than January 1st of next year, must use the fund to provide opioid antagonists to eligible entities, including boards of education. So that's something to be on the lookout for if your district does choose to store and administer opioid antagonists on campus. And then the final thing I'm going to cover before handing it over to Tom is that the new law directs the State Department of Education to conduct an audit of state and federal testing requirements and the administration of those tests. So, and the audit has to focus on the statewide mastery examination, as well as local standardized assessments that are used to monitor student and district academic progress and achievement. And it also has to focus on the amount of time that's devoted to student preparation or educator instruction for these assessments, including the time that such preparation and instruction takes away from regular instruction. So I will hand it over to Tom to finish our lightning round in the last 4 minutes that remain.
Thank you, Dori. And just to very briefly touch upon new requirements, there are new in-service training requirements, and that's a perennial favorite of the General Assembly. We add to the list every year. And this year, school violence prevention, conflict resolution, and prevention and response to youth suicide and bullying, that all has to be addressed. But significantly, each school is required by law now for 10 years to have a school security and safety plan in alignment with the Department of Emergency Services and Public Protection guidelines. This training has to be included, the specification of this training has to be included in that plan, but it must be provided annually. And we see that non-certified employees have the right to participate in that training. There's also in-service training requirements concerning seizure response. That's a new requirement to recognize signs and symptoms of seizures and to provide appropriate first aid. That's a new requirement as well. And there's also a requirement for special education updates on an annual basis. Every year that teachers and administrators have to receive training on the laws governing the PPT process and Section 504 plans, and an update of any new state or federal policies or statutes regarding special education. The General Assembly did not want to leave administrators out. And so now there's new training requirement or professional development requirements for principals and vice principals on management of school personnel and methods for engaging personnel with school goals. I'll be interested to see what that training looks like, but it is now a requirement. And finally, as we know from last year, paraeducators are required to receive the same, or not the same number of hours, not the same training, 18 hours of professional development each year. And starting with this year, the program of professional development is to integrate principles and practices of social emotional learning and restorative practices. And we also see the General Assembly taking pains not to let people cheat and use other trainings to substitute for this new required training. So DCF training, sexual harassment, bloodborne pathogen trainings can't count toward this statutory required training. And I hope we haven't worn you out. I know I'm a little bit dizzy from all of these legislative changes. We hope it was helpful to you, and we appreciate your being with us this morning. And I believe that the slides will be sent out to you later. And with thanks to all of you for participating, I'll turn it back to Tiffany.
Thank you, Tom. And Dori, I have one more follow-up question regarding personal finance, and I think it's more of a clarification. Someone put in the Q&A, their school has a separate half-credit personal finance credit or class. However, it can be fulfilled with either a 1 credit math, STEM, parentheses, or one of our half credit business classes. Since it's listed as a separate half credit, can those classes now only count as personal finance and no longer STEM? And they're clarifying based on the last Q&A question that you answered. So students cannot let that single class count as both math and personal finance, correct? Or both business, STEM, and personal finance. Does that make sense?
I would have to look at the specific things for the program of studies of whatever school district it was. What the law provides is that the half credit can be part of a humanities or as an elective. It doesn't mention STEM at all. So I would have to see what the program of studies looked like and how that could count. But that's what the statutory requirement is. The good news is we have a couple of years to figure this out and how to implement it.
Thank you. So thank you both so much. It was a busy legislative year. We know that. You did a great job of capturing everything for us. And as I had said, the recording will be emailed out or sent out to all of our registrants. So just to like to take a minute just to plug a couple of things that are coming up in CAS. We have ins and outs of Section 504. So for those of you who have a team who would like to attend that, that is a Zoom. So that's a virtual one, which would be great. We have play-based learning, which I posted in the chat. We have 2 workshops coming up with overviews of what play-based learning should and could look like within schools. And those are repeated on the 2 different dates. We also have how to stay ahead in a world of AI, which is going to be I think a fantastic workshop, not only talking about AI in terms of the educational setting, but also how we as administrators can use AI to work smarter, not harder. And then we also have our Welcoming Schools initiative. So for every school, which I think is every school that is trying to make your school more welcoming to parents, that is an overview of a program that is being offered through the state in connection with CREC. So we're offering that on October 24th, 2 times during the day. So hopefully it fits into somebody's schedule. I have the registration link for all of our CAS workshops in the chat. And if anyone is ever looking for anything else, please let me know. And we will be glad to look into either setting that up for our members or looking at where we can help you find professional development on certain topics. All right, so thank you again to everyone who attended. Thank you, Tom and Dori, and we hope to see you again soon.